versus James Egan Holmes, case number 12CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We are outside the presence of the jury. Oh, we were not on the record.
Outside the presence of the court reporter, too.
Apparently. Miss Martin, are you ready? Are you sure? All right, now we're on the record. This is the people of the state of Colorado versus James Egan Holmes, case number 12CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We are outside the presence of the jury. Did the parties want to chat about the last bench conference?
Sure.
All right. What is it that the people have in mind? The request was to have me make a finding that the defense opened the door to evidence that I have excluded. And I agreed with the people that the door has been opened to that evidence. And the question is, what are the people intending to do in terms of, is this something that you're intending to bring up in your cross-examination of the witness? And we should probably have Dr. Woodcock step outside for just during the time when we're having this discussion. Are you intending to go into it in your cross-examination, or are you intending to introduce the evidence later? And for the record, Dr. Woodcock has stepped out.
Your Honor, it may be both, and I say that because it sounds like, based on Mr. King trying to redirect him on some of those questions, he was unaware of anything that may have existed. I think that creates two opportunities here. One is to question the thoroughness of his review of the materials in this case, especially when rendering an opinion of this significance, and then two, possibly to bring it in then on rebuttal or through another witness to show that it actually existed and that he did miss it.
And what you're intending to bring up is the incident related to the defendant driving through a red light and apparently receiving a ticket in the mail for it. Is that correct?
With that photograph, Your Honor, yes. And I think the court will recall, too, there's another email that was part of an email exchange, and I can't remember if it was the CU emails or the Hotmail exhibits, Your Honor, that made reference to yet another speeding violation that he received that he talked about contesting with his mother and then making the decision.
It was Exhibit P-TR-1227. It was the CU emails.
Yes, sir. I think that's right.
And that information was redacted based on the objection from the defense. All right, Mr. King, anything else from you?
No, not this time.
All right. I do think that the door has been open. I can't remember which order it was, but I ruled that the incident where at some point before the shooting, I think it was the beginning of July or the second week of July, I want to say July 11 or so, but I may be wrong. I'm going off the top of my head. Does anybody remember the actual date? No.
No.
Okay, we'll pull it up. Ms. Gerlings, do you know which order that was? All right. I think
Order D73, Your Honor, or 73B or something like that.
I'll pull it up.
The Apple's telling me July 10th, Your Honor.
Okay. All right, it was order D73B. And apparently, on or about July 10, 2012, the defendant, while driving, tried to make a green light, and in the process, the light changed. The light was red. He still went through, and this was captured through one of those cameras, traffic cameras. And the prosecution has one or two pictures, I think maybe a couple of pictures of the incident. The defense filed a motion asking the court to exclude that evidence. I ruled in order D73B that it would be excluded. At the bench conference, the people argued just now, a moment ago, before the break, that the defense had opened the door. And I found that the defense had, and I agree still that they have. Here's the question that was asked. The question was whether the defendant was a chronic rule breaker. This was the question by Mr. King. The witness responded no. Then the question was, to the contrary, was he, prior to this incident on the 20th of July, 2012, was he a chronic rule follower? Dr. Woodcock then answered yes. The question then was whether there was any indication that the defendant had ever broken any laws or rules or harmed anybody. And the answer was he hit his sister in a basketball court. And so at that point, Mr. Brockler asked to approach. I found that the door had been opened, and I have said before that I have issued a lot of rulings in this case. Some of those rulings exclude or limit evidence, and the parties have to be careful not to open the door to evidence that has been excluded. After the bench conference, Mr. King attempted to clarify the record, but I think, although unintentionally, probably ended up confirming what was said before. The question was, do you know whether he ever received a traffic ticket or a speeding ticket or red light ticket or something like that? And then Dr. Woodcock answered, I'm not aware that he has. I think an inference can be drawn from that, that if the doctor is not aware of it, that then the defendant has not ever received a traffic ticket. So although Mr. King was attempting to remedy the situation, I think in a way it may have made it, the follow-up question may have made it worse. So I think that the door has been opened, and so for that reason I will allow the prosecution to cross-examine Dr. Woodcock by asking about both the incident that I excluded in order D73B, as well as the information that was redacted from People's Exhibit P-TR-1227, which referred to a speeding ticket in, I believe it was the end of 2011. I think it was October of 2011, I believe, the fall of 2011. And there was an email between the defendant and his mother. Actually, it was an email exchange, and there was a mention in a couple of emails, perhaps a few emails, and certainly in a couple of different dates about this speeding ticket that the defendant received, and the fact that he was annoyed that there was almost no leeway in Colorado by the police officers because he was only speeding, I think it was less than 15 miles over the speed limit. He was driving less than 15 miles over the speed limit. So, I agree with Mr. Brockler that it's relevant for the two purposes that he indicated. One, because it goes to rebutting what the witness said, and two, because it goes to the thoroughness and reliability of the expert's opinion. So I'll allow that on cross-examination. All right. Is there anything else we need to talk about before I bring the jury in on behalf of the defense? It's your witness, so I'll ask you first, Mr. King.
No, Your Honor, other than I informed Mr. Brockler, I don't know how long Mr. Brockler is going to be, but I informed Mr. Brockler we have one other witness who's a deputy from the jail who has some kind of medical procedure scheduled, I think tomorrow, and today is the only day he may be available to testify. I would like to get through Dr. Woodcock. I also would like to accommodate this deputy's schedule. But, so I just want the court to know, I may be asking to go a little bit long, depending on where we're at, or if that's acceptable to the jury.
How much longer do you have on direct examination?
5 minutes.
5 minutes? And do you have a lengthy cross?
I think I do, Your Honor, but it depends. And if the court's willing to entertain this, I spoke with defense counsel about this, and I appreciate him bringing it up to me in advance. The idea that we might, if we weren't going to finish with Dr. Woodcock prior to 5, maybe taking a small interruption from the cross-examination to permit this witness, who I've been told is at best maybe 15 minutes, and put him on so that he can then go about his business, and then we may have to reconvene tomorrow to finish up the cross if there's any that still exist.
Is that okay with you?
Yes, Judge, can we see where we're at about 4:45 or so, and
That's fine.
approach the bench at that point?
I can ask the jury also when they come back in if they can stay till 5:15. Would that help?
Yes, literally this deputy would be on the stand for as long as the nurse was this morning.
Okay.
So.
All right. Let's bring the jury in, please. Thanks for bringing that up to my attention. Please be seated. The record should reflect that the jury is back in the courtroom. Welcome back, folks. Right before the break, Mr. King was finishing up his direct examination. Dr. Woodcock, I remind you that you're still under oath. And Mr. King, you may finish your direct examination at this time. Actually, before you do, Mr. King, I want to ask the members of the jury if everyone is okay staying until 5:15 today. Is there anybody who cannot stay until 5:15 today? Okay, nobody's raising their hand. All right, we'll try to finish by 5, but there's a chance we may go past 5. Thank you. All right, Mr. King, you may proceed.
Thank you, Your Honor. Doctor, before the break, we had a discussion about your analysis of prong 1, whether or not, of sanity, whether or not Mr. Holmes lacked the capacity to distinguish between right or wrong. Let me ask you, have you formed an opinion as to whether Mr. Holmes did in fact lack the capacity to distinguish between right and wrong on July 20th, 2012 due to the mental disease or defect that he suffered from?
Yes, I have.
And what was that? Was your opinion that he lacked the capacity or he had the capacity?
It's my opinion that he lacked the capacity.
Now,
Yep. Okay, the objection has been withdrawn. Go ahead, Mr. King.
And just to clarify that opinion, Doctor, were you making that, do you form that opinion based upon a standard which is whether the person lacked the capacity to understand the difference between right or wrong based on a moral, societal moral standard, as opposed to understanding that it's illegal?
Yes.
I'm sorry, Ms. Martin, did you miss something? You got it? Okay, thank you.
With regard to the second prong, whether or not Mr. Holmes, due to a mental disease or defect, lacked the capacity to form the required mental state for murder, which is that he acted intentionally and after deliberation. Do you think that it's important in making that analysis that, again, we look at things from inside, to the best of our ability, from inside the mind of the person involved at the time that the crime is committed back in July of 2012?
That's the essence of what we're being asked to do, yes.
And is part of that analysis to analyze, well, first of all, is your understanding that deliberation requires some exercise of judgment?
Yes, absolutely.
And would you then have to analyze whether or not the person was acting after deliberation with some exercise of judgment based upon their mental state at the time?
Yes, deliberation involves reflection and judgment. It involves the capacity to see oneself and to modify one's behavior based upon that observation. That's what deliberation is.
Can psychotic delusion interfere with judgment?
Absolutely.
Have you formed an opinion based upon your analysis of the case to a reasonable degree of psychiatric certainty whether Mr. Holmes, due to his mental disease or defect, lacked the capacity to form the required mental state for murder, that being acting intentionally and after deliberation?
That's correct. I don't believe that he had the capacity to form an intent or to deliberate because of the complexity and overwhelming presence of these delusional compulsions. Is there any real doubt in your mind about the conclusions that you've drawn today that Mr. Holmes suffers from a serious psychotic mental illness and did at the time, and that illness and that he meets the legal criteria for insanity on July 20th, 2012?
Sustained. Same type of objection I sustained for you earlier, some weeks ago. Why don't counsel approach? Okay, with that clarification, you may proceed, Mr. King.
Are you confident in your opinions?
Yes.
Thank you. I don't have any other questions.
All right, cross-examination.
Thank you. Doctor, you'll recall that after I finished voir direing you on your qualifications, Mr. King asked you some additional questions about your experience and your opinions on the forensic subspecialty. Do you recall that?
Yes.
I just want to make sure that what you're not saying is that someone who has the subspecialty of forensic psychiatry, that's not some marketing gimmick to get employment. You're not saying that?
I never said that.
Okay, and I'm glad you cleared that up. Thank you. And the fact is, as you testified, to get it, it's not just you submit an application. You've got to do some pretty intensive things, in your opinion, for at least a year to qualify for that. Fair?
Yes, it's called a fellowship. It's a year-long training program. Then you have to pass an examination.
That's right. And that's no small feat.
No?
In fact, it's too big of a feat for you to trade what you're doing now to get that kind of certification. Fair?
I've chosen not to do it.
Exactly. Now, the reason that's important is because the forensic part of psychiatry is not just I'm testifying in court, but it's the application of law to the psychiatric information that's presented and evaluated. Fair?
Yes.
Okay. So one of the things that Mr. King asked you about was how many times you've been qualified as an expert. Do you remember that question?
Yes.
And you understand that to be qualified as an expert requires a court, like this judge, to say that you're qualified as an expert, right?
Yes, I understand that.
Okay, your answer to the question was, I've been qualified as an expert several hundred times. Do you recall that?
Yes.
Now, in looking at your provided testimony, and I'm talking about even stuff that we've obtained going back to 2000, it appears that at most you have testified at trial some 50 times, going back over 15 years. Does that sound fair?
It's more than that over my career.
I understand.
And I believe that, okay, so you're asking about being qualified as an expert at trial rather than testimony, which would include deposition.
And doctor, you would agree with me, wouldn't you, that testifying at a deposition is not being qualified as an expert?
Yes, you're correct. I think I stand corrected in terms of that number because I was including my deposition testimony, in which case I would not have been qualified as an expert. So being qualified as an expert would have taken place in court, and it wouldn't be a couple of hundred times. So I've testified several hundred times, but not in court as a qualified expert.
And to be clear, at least over the last 15 years, we're talking about having been qualified maybe 50 times. Fair?
In 15 years, probably, yes.
And of those 50 times, only one before today has been to apply this criminal sanity statute to some set of facts and psychiatric evaluations. Is that fair?
Yes.
This is the second time, right?
Yes.
And that's important. The forensic piece of this is important because of this book right here. And I'm holding up what looks like the Diagnostic and Statistical Manual of Mental Disorders, 5th edition. Are you familiar with this book?
Yes, I am.
Certainly are. It's the Bible. May I approach, Judge, with this?
You may.
You'd call this the Bible, wouldn't you, for psychiatry in terms of diagnosis and criteria and all that?
Actually, I've never called it that.
Oh, I was using a term Dr. Gurr used. What term would you use?
Well, I think it's fair to describe it. It's a consensus statement from committees organized by the American Psychiatric Association to describe the best current understanding we have for the diagnosis of psychiatric disorders. So it's organized across the spectrum of psychiatric disease, and it includes diagnostic criteria for psychiatric disorders, and actually it's a very good textbook.
And more than that, you would rely upon it for the criteria for schizophrenia. Fair?
Well, that's how the system works. It's called a nosology. That is, there's a technical definition for everything, for all of these diseases. If you read the introduction, you'll see that it's not to be treated as a Bible, that it's not to be taken really quite literally. It's a nosology, a collection of criteria that is our best understanding. I can tell you DSM-5 will not be here in 10 years. There will be a new edition, and there will be new criteria. And so it's a guide to diagnosis. It is not the word of God about diagnosis. It's a guide for application in clinical settings and for insurance coding.
Doctor, is the answer to my question yes, I rely upon that?
Well, I've tried to tell you how I rely upon it and how I use the DSM. I use it as a guide.
You wouldn't substitute your own criteria for schizophrenia or delusions or hallucinations if they differed with the ones in there, would you?
I wouldn't substitute my definitions because these are the official definitions, but I might apply, but I always have to apply these definitions in the individual case according to my professional judgment. And that's exactly what the textbook says to do.
I understand. And do us a favor then on this book that you rely upon in the manner that you've described. Could you find for us in there which diagnosis equates to insanity under the laws of Colorado?
That's easy.
Oh, okay.
There is none. You know that.
So that book doesn't speak to the application of Colorado's laws to any diagnosis, right?
That's correct.
So it's fair to say that you can have any of those diagnoses and still be legally sane in Colorado, correct?
Yes. That's why I'm saying that the information in this book as a guide has to be applied by the professional in the individual case.
Thank you for the added part. Let me just follow up by asking you this then. What's important then is not the diagnosis, but how whatever that diagnosis is impacts a person's functions within the context of this state's laws, right?
Yes, which you can't know if you don't know the diagnosis.
Okay. You'd agree with me, the diagnosis does not drive the determination on sanity. The function of the person with whatever diagnosis it is, that's what drives sanity.
My point is that the diagnosis allows us to make that determination. Without the diagnosis, without a diagnostic formulation, I don't think you can really make a determination of sanity because you don't know what's wrong with the person.
Okay, here's what we'll do. Let's start with how you approached this case, and then we'll work forward and see how you came up with the diagnosis and what difference it could make to the function of this man back on July 20th, 2012. Fair?
Fine.
Is it fair?
Well, yes, you get to ask the questions.
Thank you. Doctor, you were contacted by the public defender's office, as Mr. King got out of you, to come do a limited review of the defendant for what you said was about 2 hours, correct?
Yes, my notes say 2 hours and 45 minutes.
But is it really 2 hours?
I'm sorry, I don't understand your question.
Well, my question is, you testified that you saw him for 2 hours. Your notes say 2 hours and 45 minutes. Which is true?
I'm saying that my recollection of 2 hours was incorrect. My notes say 2 hours and 45 minutes.
Now, that's interesting because that same recollection finds its way into your report of March 26th, 2015, right?
I don't know.
Do you have a copy of your report in front of you?
I do.
Take a look at it. And now what I'm referring to is what you have entitled Forensic Neuropsychiatric Evaluation and Report.
Yes.
Right at the top, it says examination, colon, in bold. What does it say?
At the top?
Well, right here, I'll read it to you. Do you see here on page 1, examination, colon, I interviewed Mr. Holmes for approximately 2 hours?
Yes.
And that's what you testified here to today, fair?
Yes.
And is it just in reviewing your notes since you've testified at 2 hours that you realize you made an error?
Yes.
Okay. And that can happen, okay? I get it. Before you went out there, though, you had heard of this massacre at the theater, right?
Yes.
Sustain to the form of the question.
Doctor, what had you heard about this case before you went into that cell to talk to the defendant?
Certainly the news reports over the prior several days.
Multiple dead, right?
Yes.
Multiple injured, right?
Yes.
You'd heard about a booby-trapped apartment, right?
Yes.
You'd heard about the initial evidence of extensive planning leading up to these things, right?
Yes.
Before you go in there on the 24th, and that is like 4 days after the defendant is arrested behind the theater. Is that fair?
Yes.
You had a conversation with Mr. Bishop, correct?
Yes.
And is this Mr. Bishop right back here in the blue suit and I would say gray hair, but I have it too, the less than blonde hair?
Yes.
Okay. And when you met with him, he revealed to you that he had, in advance of your interview of him, already spoken with the defendant at length.
I don't believe I knew that until afterwards. He did give me some information, but he didn't tell me about an extensive interview until afterwards, as I recall.
And that's something to factor in, isn't it?
It's a fact.
Well, let's talk about the difference then between clinical and forensic. In a clinical setting, when a patient comes to see you, you have, in large part, a lot of trust in them as a historian, as someone that reports to you what they're feeling and what they're going through. Is that fair?
It's variable. It's one of the things that I assess in every interview.
Right. And usually what you're looking for there is, do they have some ulterior motive to want to share information with me that may be less than forthcoming or less than accurate, right?
That's one of the reasons, yes, it's assessed.
Okay, and that was the situation that Drs. Fenton and Feinstein found themselves in when the defendant came to speak with them between roughly March and early June of 2012, correct?
You say this situation. Yes, it was a clinical situation, and they had to assess the reliability of his history.
Now, different when you got to him, correct?
I don't think essentially.
Let's talk about what may not be essentially different. By the time you met with him, one, he was in jail, correct?
Yes.
He was in jail for the allegations of murder of at least 12 people, correct?
Yes.
And that there were discussions that this could turn into something bigger in terms of a sentence beyond just life in prison, correct?
Objection, Judge. That calls for speculation, lack of foundation.
Overruled?
Go ahead, doctor. Were you aware of that?
I don't understand your question.
You were aware that this was a case that had potential ramifications bigger than just life in prison for that guy right there, right?
Yes, this was I understood this could be a capital case.
And so to say essentially it's the same as a clinical visit is to disregard the fact that when you meet with him, he has potentially a motive to want to tell you things that might help him in that situation. Is that fair?
Well, yes, I was referring to the fact that in both situations, both in the clinical situation and the health service and with me, those doctors and I as a doctor have a need to assess his reliability and the potential that he may not be telling me the truth or withholding information.
It's much more elevated for you sitting in a jail with a guy accused of killing 12 people and injuring 70 others than it is with someone who comes in from the student health services talking with 2 psychiatrists. You'd agree with that?
Well, I can understand that that would be your perspective. I take the obligations of my profession and in each patient very seriously, and I consider that very important in every patient interaction that I have.
So that I'm clear, what you're testifying to right here is that you have the same level of scrutiny with this guy sitting before you in a jail cell on July 24th that you have with someone who makes an appointment to come see you about any other mental illness.
The situation is obviously very different. The clinical approach is not very different.
Now, with forensic psychiatry, one of the things that they do in taking into consideration this possible ulterior motive is rather than take the person at their word, they look for as many collateral sources to either confirm or deny things that they're being told as possible. You'd agree with that?
Yes.
Going into this interview on July the 24th, 2012, you had only those news reports that you've sort of generally told us about thus far, correct?
Yes, and for that reason, it was not a full-blown forensic psychiatric evaluation. It was a very limited evaluation.
I understand, and we'll get there. Now, there are 14 pages of handwritten notes that you generated about this particular session, correct?
I generated them during the session.
You generated them during the session. And that's a little bit different than what you normally do, isn't it?
No.
Well, normally, and I'm going to go off of some testimony you provided in a deposition in, I think, 2011, normally you sit down and type out the history that your patient gives you so that you can edit it and correct it right then and there. Have you testified to that in the past?
Yes, I'm referring to the fact that in both situations I'm writing down. I didn't have a computer. I was in a jail. I couldn't use a computer. In both situations I'm writing down as the interview is progressing what goes on in the interview.
You were told you couldn't use a computer? Did the jail tell you that, sir?
Yes.
When?
Well, I left my cell phone. I left my keys. I didn't bring in my computer.
You didn't ask them to, did you?
I didn't know I could, no.
Understood.
I'm not sure I would have used it in that situation. In the office with a computer setup, it's pretty different than a laptop on your lap. But in both situations, I'm recording the interview as I sit through it, and that is my custom.
I understand. And the importance of those notes, in this case, the handwritten notes, is because you need to have something to recall about the specifics of the conversation for some future date.
Yes, I'm recording the data from the interview. I've done this for 30 years.
So the answer to my question is yes, so that you can use it for some future date, right?
Yes.
Because you can't be counted on to memorize every single thing that's been said, even over a small 2-hour period of time, right?
Yes, that's absolutely
One of the
correct.
things that you testified to is you saw no value in conducting this interview over video. Do you recall that?
Yes, I've decided not to conduct interviews that way.
Now listen, I think we've all sat here and watched you read pretty extensively from your notes in answering Mr. King's questions. Would you agree with me that we wouldn't have had to do that, and we wouldn't have to rely upon your notes if we'd have had a video of your 2-hour interview of that guy on July 24th, 2012? Is that fair?
That's fair.
And one of the other things you said is, hey, I didn't want to videotape this because, and videotape may be a 1980s term, video record this is because it could be distracting, right?
Yes.
One of the things you'll agree with that in forensic psychiatry, one of the things that you are encouraged to do is to conduct any interview, any evaluation without the defense attorney or member of their team in the room with you, right?
That's a general guideline, yes.
Right. And in this particular case, Mr. Bishop insisted on being in there with you.
No, he did not.
You asked a defense investigator to sit with you?
I know that we had a discussion about it and I agreed to it. If I had objected, then he would not have been there. Given the circumstances of the interview and what I was being asked to do, that this was the first psychiatric contact that Mr. Holmes had had, and given Mr. Bishop's background, I thought it was appropriate to have him there as an observer.
Why? Why do you need him to observe? You're an expert.
This was a preliminary, a first look at Mr. Holmes, a preliminary psychiatric evaluation, and I thought that it would assist in communicating information to the team to have another clinician there.
To have another clinician, you know he's a public defender investigator. You know
Yes,
that.
I'm aware of that. He's also a social worker.
Has a master's degree in social work.
Yes.
Right. Do you know if he practices social work or has in the last 10, 15, 20 years? Do you know?
I don't know that.
Was that something you thought, hey, I'll ask this guy about that before I invite him into this setting that I know a general guideline says I shouldn't do?
No, I knew that he was a social worker and that he was a member of the team. I thought, given the limited scope of this evaluation, that it would be helpful in providing information to the team to have him there, and that's why he was there.
Well, you were taking notes to provide the team with information, correct?
Well, that's a different issue.
How so?
Well, whether I take notes doesn't depend on whether or not I invite him to observe the interview. Those are different issues.
So, and I don't want to belabor this, but you've told us there's a general guideline that says you ought to conduct these interviews by yourself. You said I deviated from it because I thought it would be helpful to the team, I presume you mean the defense team, to have another person in there watch me do this.
This was a very limited scope evaluation. It was a preliminary evaluation, and I didn't feel that the guideline applied to this situation. I used that judgment.
Okay. Thank you. And there were actually a couple times where Mr. Bishop's interactions throughout this, you felt compelled to document them in your handwritten notes, correct?
Mr. Bishop's?
Yep.
I think there was just the one incident.
Okay, there's also a reference to Mr. Bishop here in a certain part where you refer to him as SB. You remember that? I'm going to try to find that page for you, sir. And I don't want you to get into the subject matter of that, only the reference to it. Here on page 11, third of the way down. Sounds like you put parenthetically in there a statement that Mr. Bishop made. And I'm not asking you to tell us what that statement is, sir. I'm asking you to acknowledge that he jumped in and provided an answer for the defendant to one of your questions.
I'm not sure what that reference is.
Well, they're your notes.
I understand that. I still don't know. Usually when I put things in parentheses, it's what I'm saying, so.
Well, here, though, you've indicated SB, Stephen Bishop said it.
I don't know if that's what that means. Possibly he did say that. That's possible.
Okay, so it's very possible that he actually objected and helped the defendant answer at least one question during your interview, right?
I don't know. I can't say based on that reference.
Are there other parts of these notes that you don't recall, the way you don't recall whether or not Mr. Bishop jumped in?
Yes, most of it I don't have primary memory of. It was 3 years ago.
Okay. There's a transcription of these notes. Do you recall that?
Yes,
And you made that transcription how long after the handwritten notes?
about 2 years.
So for 2 years, and so that I'm clear, we had 14 pages of handwritten notes, and that's it, right?
Yes,
And then my guess is someone from the defense team called and said, hey, we need to be able to read these things and consider them. Can you type them up?
essentially, I think that's what happened.
Okay. So when you've testified here today, and it looks like you're reading, are you testifying from your memory, or are you just reading what was in these notes because it was 3 years ago and you don't remember so well?
It's a combination.
Are we going to know, based on the words you spoke, which it is?
I don't think so, no. I don't have a primary memory of that entire interview, which is why I took notes.
Okay, let's talk then about how you went about taking the notes. One of the things that you did was you wanted to make sure that you distinguished between words you spoke in form of question, and you did that parenthetically, yes?
Yes.
And the exact words that the defendant spoke, right?
No, it's not exact words, always.
Were you
Sometimes it's
interpreting what
exact
he was
words.
saying? I'm sorry.
Judge, counsel needs to let the witness answer
agree.
the questions.
Well, I think he answered, and then he kept going, so the objection is overruled. Ask your next question, please.
Okay. The words that you put down in here that you attribute to the defendant, are they interpretations of what he said, or are they the words he spoke?
There's sometimes the words he spoke, there's sometimes summaries. I'm not capable of writing down verbatim the whole conversation. So I'm taking notes through the conversation. They're quite extensive, as you can see. I mean, it was 14 pages in 2 hours and 45 minutes. But it's not a verbatim transcript.
Video might have helped with that too.
Obviously, a video would have given us a verbatim transcript.
And the way he reacted to the different questions and stuff that you asked and the things that he said, right?
Yeah, so
Okay.
I'm left the professional arbiter of his reactions during that time.
So when you go into this setting 4 days after the arrest of the defendant behind the theater, you're in there with Mr. Bishop, and you know only what's been in the press. Do you know anything about his physical condition before you go in there?
I don't recall specifically. I don't think I had any specific information. I certainly wasn't told that there was anything wrong with him physically.
Right. The other thing that you knew is that he was unmedicated, correct?
Yes.
And in fact, based on a later page in your handwritten notes here, you confirm with the defendant that he took himself off of any medications he'd been provided as early as May, right?
I believe that's correct.
So he had been unmedicated, by his own words, maybe 2 months before you saw him. Is that fair?
I think that that's fair. I don't know the exact dates.
Understood. Now he is able to provide to you over the course of this 2 hours a pretty detailed set of recollections. You'd agree with that, wouldn't you?
Yes.
Now one of the things you testified to is you started getting into the background of the defendant. Do you remember that?
Yes,
And your characterization to this jury was that he told you that he had a pretty typical middle-class family. Fair?
yes,
Now, far from those words appearing anywhere in your notes, what he did say was that regarding his parents, if his parents didn't get along, he hid it well. They hid it well. Do you remember that? This is page 3, sir. I know you got to look at it.
yes,
And below that, he tells you people show what is in their best interest to show. True?
yes,
And those are his words, not your summary of his words.
yes,
He also talked about the fact that he had no contact with his sister, really. Right? That's on page 1.
yes,
And that he really didn't talk with his parents much.
yes,
He doesn't like initiating conversation even with them. Right?
I'm sorry, where does it say that?
In touch with family, very little, doesn't like to initiate conversation. It's that's right, top third of that first page. See that?
Yes,
Now, and again, I feel like what I'm asking you to do is to just simply agree with me that this appears in your notes. Do you have any independent recollection of what he told you back then?
Objection asked and answered.
Sustained. You can rephrase if you want to ask with respect to this specific area, but it's, in general, it has been asked and answered.
Thank you. Here's what I'll do. Doctor, if I ever ask you a question about something that the defendant said to you, and you don't remember him saying it but appears in your notes, would you let us know?
sure.
Thanks. In fact, he said he talks to his parents about once per month. Is that right?
Yes, it says that in my notes. I don't specifically remember him say it, but I wrote it and transcribed it.
And in fact, he asks, what reason is there to even have contact with his sister, right?
Yes, I remember that.
Described her as a 19-year-old dropping out of college, right? It's above that, Doctor.
Yes,
Thank you. Now, below that, we start to get into some of the stuff Mr. King asked you. I almost called him Dr. King. I'm sorry. Mr. King asked you about him dropping out of school. Do you recall that? Do you recall that exchange you and Mr. King had about it? Okay. One of the things that you testified to is that he quit in large part because the anxiety he was feeling created trouble for him presenting in grad school. Do you remember saying that?
yes, that was one of the reasons.
Can you do me a favor and find where that is on this first page that he tells you that?
I don't think that was, well, let me look here. That's on page 3.
On page 3, where it says he had trouble with presentations?
Anxiety was interfering with school work, hard to focus in discussion groups.
Hard to focus in discussion groups. Now, you explored that with him, didn't you?
Well, we reviewed it. I don't,
Okay.
but certainly we talked about his anxiety at length.
But to be clear, at no time in any of these notes is there a reflection of him telling you, I had trouble with my rotational presentations, my class presentations. His reference to you, true or false, is that it created anxiety in discussion groups.
Well, much of my testimony has been based upon the extensive review that I've done. I'm not purporting that all of my testimony is based on this interview.
Sir, I'm going to disagree with you on this last part. Here's why. That answer to the question was when Mr. King asked you during the interview on July 24th if he told you why he quit school. Do you remember that?
Judge, I'm going to object to the phrasing of the question, that counsel disagrees with him for some reason.
That first part of the question is, the objection to the first part of the question is sustained. The rest of the question is appropriate. So you can answer the question.
Doctor, do you remember Mr. King specifically asking you about your July 24th interview if that guy told you why he quit school and you said because he had anxiety giving presentations in grad school? Did you say that or did you not say that?
I think I said that.
Okay. So, and that was without reference to anything you did 2-3 years later, right?
I'm sorry, I'm not following that
Well,
connection.
let me help. When you went in there to interview him, you had no information other than what he gave you, correct?
That's correct, yes.
And when Mr. King was asking you about the information you got out of the interview for which you had no prior information, he said he quit school because he had anxiety giving presentations in grad school. Do you remember that?
Quite frankly, I don't remember the specific context of that question and whether Mr. King was referencing only that first interview or he was referencing other information that I've reviewed in regard to this.
Doctor, did we spend maybe 2.5 hours in here just talking about page by page your notes from July 24th?
Judge, I object. In the context of asking about the pages page by page, I asked him a lot of other questions that related to a lot of other issues that came from a lot of other sources.
The objection is overruled.
Go ahead, Doctor. Do you remember that?
Quite frankly, I do not remember every question and the context of every question that Mr. King has asked me today or what my answer was, and I certainly don't remember this one specifically. If you want to have the court reporter go back and pull that up, I'll be happy to consider the accuracy of my answer. But I think it depends a lot on the context of that question. I've not given all of my opinions just based on this initial interview.
No, I understand. But to the extent that we're talking about what you heard from the defendant on July 24th, you have limited your responses to what you heard from the defendant on July 24th, right?
Yes, I've tried to be complete and careful in my answers.
There's another part. You referenced to Mr. King when he asks you about what was told to you on July 24th, where you talked about the defendant telling you that he suffered from dysphoric mania. Do you remember that? And you actually even said dysphoric means uncomfortable or painful. Do you remember that?
Yes.
Can you do me a favor? And I may have missed it, Doc. There's a lot here. Can you go through those pages and tell me if you find the words dysphoric mania in there anywhere?
I don't think that the term dysphoric mania appears here in this interview.
Is it fair then to say that when you testified about that being told to you on July 24th, you remembered that independent of what was in your notes?
Judge, that's a mischaracterization of the testimony. He didn't testify that that was told to him on July 24th.
The objection is overruled.
Go ahead, Doctor.
One of the reasons I've been looking at my notes of this interview is that I want to give accurate answers. I don't believe that I ever stated that the term dysphoric mania was from this interview. So I either misunderstood the question or Mr. Brockler's misrepresenting the question that
I object.
Overruled.
Go ahead, Doctor.
I don't recall that specific set of answers. May I look at my notes?
Take a look at all of them.
Thank you. On page 10 of my notes, when I asked him about hallucinations, it says visual movement without cause. And he said that when he was an undergraduate, he experienced flashes to the side when I couldn't focus. They were sometimes distracting, and he never sought help for it. I do remember him telling me about the undergraduate flashes.
Okay, but that's it, right? In July 24th, that's all he talks about are some flashes in undergraduate.
I believe that that's all in my notes at that time.
And to be clear, he never tells you at July 24th that he was seeing shadows, right?
I think that's correct,
Because you'd have put that word in there, right?
probably.
And because you use the word flashes, we can conclude that had he said fleeting, you'd have put that word in your notes, right?
Well, I've already said that it's not a verbatim transcript, so...
But you don't remember him saying fleeting, do you?
No, I don't.
You don't recall him saying that he was hearing any voices?
I think he told me he was not,
Not hearing any voices?
yes.
Not even voices commanding him to do something, right?
That's correct. That is, voices in his head.
Yep. He also never tells you about trichotillomania. Do you know what that is?
Yes, I do, actually.
That's that hair pulling thing, right?
Yes.
And I could be wrong here, Doctor. Again, they're your notes, but do you see somewhere in there where he told you he was pulling his hair like that?
Judge, beyond the scope, I never asked about trichotillomania or hair pulling.
Overruled?
I don't see that in my notes. I don't recall it.
So we can presume he didn't tell you that because that would have been documented.
I think it would have.
Okay.
I know I read it elsewhere, but
Sure. But he didn't tell it to you 4 days after the event?
I don't believe so.
Okay. Something else. You specifically asked him if there were any thoughts of control. Do you recall that?
Yes?
And he said no, didn't he?
Yes.
Never used the phrase a master power seemed to have taken over or commanded him or controlled him. Never said anything like that.
Not during this interview, no.
Because you'd have documented that, right?
I think I would have remembered it too.
All right, listen, I want to talk to you again about some other information that he was able to recall for you with some detail here. He says that he drops out of school, he quits in his terms, of his own choice, right?
Well, he was unclear about that. He said he felt as if he was being asked to leave, but he didn't say he was being asked to leave.
Did you explore with him who he thought was asking him to quit?
Not at any length, no.
Just wrote it down.
When the interview continued, yes.
Okay. One of the things, though, that he makes clear to you, though, is that he could have kept doing the work. He just didn't want to anymore, right?
Yes, he lost motivation.
And he said the one thing that he could do the things he had motivation for, correct?
Yes, he continued to do things.
And one of the things that he told you he had motivation for was killing people, right?
Yes, that was part of his delusional motivation.
But that's what he told you, is he had motivation to kill people, right?
Yes.
Okay. He goes on to describe his background in college, which he described as wasted time, didn't he?
What page is that on?
Top of page 2, where it says
Yes.
college, wasted
He said
time.
it was time to get here to his present program.
He talks in detail about his degrees in neuroscience and his interest in economics and military history, right?
Yes.
In fact, he even recalls for you to the 1,000th place his GPA, 3.949, right?
Yes, students tend to do that these days.
Pretty proud of that, isn't he?
Yes.
Proud enough that he told you, I just missed being summa. What does that, is that true?
Yes. That's
What does that
he
mean?
said. Well, it's another categorization of honors.
It means you graduated number 1 in your class, right?
No, it means that
Actually-
you were at that highest level, summa cum laude.
Okay.
Doesn't mean you're valedictorian.
He also talks about some of his extracurricular activities to you, right?
Yes.
He lists intramural soccer.
Yes.
He
Once.
also says he went to the gym a lot in undergrad, correct?
Yes.
Says he had friends. Yep.
Yes.
And that he didn't keep them because he just didn't see a reason for them because they were going to split anyway, right?
Right.
And at some point there at the bottom you write some note about Mr. Bishop coughing and a laugh. I don't know. What's that about?
Well, I addressed that before. I'm not exactly certain. I think something happened, and I was surprised by Mr. Holmes' reaction to it. I thought it was a odd reaction.
Now, on page 3, you talked about him going into detail about his apartment that he rented, telling you, in fact, that it was 800 square feet, right?
Yes.
That when you got into past psychiatric history with you, he told you that the reason for it was because he had backhanded his sister. Do you remember that?
Yes.
Now, my guess is later on, when you had the chance to review the volume of information available here, what you saw was he never repeats that as the reason for seeking family therapy to either Dr. Reed, Dr. Metzner, or Dr. Gurr. Is that fair?
I'd actually never made that connection. It could be true.
So you don't know if he told Dr. Reed, I have no idea why we went to family therapy. You don't know that?
I don't know that.
And you don't know if he told Dr. Metzner it was because my mom was having trouble adjusting from the move up north. You don't know that?
I don't recall that.
He also referred to all that therapy as another waste of time.
Yes.
Yes? You talked about his time with... Sorry. You talked about his time with Dr. Fenton and Miss Roth and Dr. Feinstein. Do you remember that?
Yes.
One of the decisions he made was, I am going to see someone for these problematic issues that's closer to where I live, right?
Well, I think he had been given a choice in the initial evaluation as to whether he would follow up in the community or at the health center. That's what I understood.
And the only thing I want to ask is, that's a completely rational decision to make about that, isn't it?
Of course. It's got to go one way or the other.
He talked about never really having a panic attack. Do you remember that?
Yes.
You went through with him interviews that he had for graduate school. How did you know to even ask about that? And I'm looking at page 4, Doc.
I had asked about anxiety, and he brought up that he experienced this intense anxiety in that setting. So he brought it up in response to that line of questioning.
Understood. You then talked about, you went back and talked with him about middle school and him not wanting to speak in general. Fair?
Yes.
And then he remembered a pretty specific GPA from high school as well. Do you recall that? Page 5, sir.
Yes.
He says he got a 3.78 GPA, but adjusted to 4.01. Fair?
Yes.
Pretty proud of that. You'd agree?
Yes.
He even told you that his SAT scores were above average. Right?
Yes. My custom is to ask specific questions about those kinds of things. How did you do? What's your GPA? How do you do on the standardized tests?
Got it. One other thing that you had indicated here, I want you to go down on page 5. 1, 2, 3, 4. 5 lines from the bottom, 6 lines from the bottom, where it starts off with, he didn't want. Do you see that?
Yes.
Now you wrote, he didn't want to build a false sense of support. You see that?
Yes.
That's actually a mistranscription, isn't it? It should have been rapport. And that's what you testified to, didn't you?
I don't think so. I think I said support.
Take a look at your notes, if you would. Do you have your handwritten notes up there?
Yes.
It tracks the pages. Take a look at that word. And here's why I ask. My recollection, and you tell me if you disagree, was that Mr. King asked you if he didn't want to build a false sense of rapport, and you agreed. Do you remember testifying to that?
No.
Do you remember ultimately, many years later, reading in the notebook that he said he didn't want to build a false sense of rapport with Drs. Fenton and Feinstein? Do you recall that?
I don't recall that. I guess it could be either word.
Well, what does false sense of support mean?
Well, it's almost a synonym for rapport in a therapeutic setting. Rapport and support are going to be closely related.
It's possible, though. It's just a mistranscription. That could happen 2 years after you took the notes, right?
I just said I don't know if the word is in my handwritten note is rapport or support. It's interesting that the word rapport showed up in his diary, his notebook, so maybe it's rapport.
Okay. One of the other things you testified when he goes to see Drs. Fenton and Feinstein is that he's ambivalent about getting help, right?
Yes.
And you'd agree, he doesn't tell you when he goes to see Drs. Fenton and Feinstein that he does it at the request of his then ex-girlfriend. Right?
Can you repeat that question?
Yeah, he doesn't tell you on July 24th that the reason he went to see Drs. Fenton and Feinstein was at the suggestion or request of his ex-girlfriend.
I don't know if that came up in the interview. I was aware that she had suggested that he seek help, but no, he didn't tell me that it was at the suggestion of anybody else.
When he talked to you about his feelings, what he said was, or his concerns, I'm sorry, was that he went to Dr. Fenton to seek help with his anxiety, correct?
Are you asking me if I testified to that?
No, I'm asking you if that's what he told you.
I'm not sure he put it exactly that way. He said he went to get help with the problems that he was having, and one of those problems was anxiety. I'm not sure he formulated it exactly that way. I think what I understood from him was that he wanted to be able to continue in his program, and he felt he needed help to do that.
With the anxiety that interfered with his group discussions that he told you about,
Yes,
correct?
the anxiety was one of the symptoms that was interfering with his performance.
In fact, one of the things he doesn't complain to you about wanting to have resolved is his homicidal ideation. Fair?
Yes, he was especially ambivalent about that because he was concerned that if he was prevented in his delusional mindset from pursuing that he could never be okay.
Is the answer to my question, yes, he did not go see Fenton and Feinstein to rid himself of homicidal thoughts?
He didn't say that's why he went. I don't really know the answer to that.
Well, let's
question.
go to your notes on page 6 where you say that he didn't consider his thoughts about harming people a problem. You recall that?
Yes.
And you testified a couple times on this word intrusive thoughts. Do you remember that?
Yes.
He never uses the word intrusive thoughts on July the 24th, 2012, does he?
No. That was a professional formulation. The compulsive delusions, the intrusive delusions were what I was referring to.
Yeah, you don't write down the word intrusive delusions on these notes, do you?
No, I don't think he called them delusions.
Well, you don't write down the word intrusive on these notes, do you?
No, I don't think the word came up in the interview.
Well, I know, because it was a professional formulation, correct?
Yes.
And it was a professional formulation that you didn't put in your initial impressions of this guy after you met with him, right?
Well, my initial impressions consisted of about 20 words. It was not a narrative
We'll get
summary.
to those. We'll get to those. One of the things that he told you was he did not want to take the antipsychotic because he thinks it would impact his ability to carry out this homicide. Fair?
Which page?
Oh, starts on 7, goes into 8. And then, throughout.
Well, what my notes say is if he did the antipsychotic, he would lose his educational future. And as I recall him talking about that, and I think as I recall, he was concerned about the cognitive side effects of antipsychotics and that they would interfere with his ability to learn.
Thank you. This brings up the Plan A, Plan B, Plan C. Let's go there. Bottom of page 7. Plan A was, as you testified to, find a fix or a cure to a neurological impairment, correct?
Yes,
Plan B was to kill everyone with biological weapons, correct?
yes,
And Plan C was to commit a mass murder like he did, correct?
yes.
And what he says then on page 8 is, when he was recommended to go on the antipsychotic, he says, what future would I have if they took away Plan C? Correct?
Yeah, it doesn't make a lot of sense.
Well, I appreciate your characterization, but to be clear, what he told you is he felt like if he took the antipsychotic meds, he would lose the desire to want to murder. Fair?
Yes, this is in the context, just as he's told me that he's lost Plan A,
Understood.
so he feels sort of desperate.
Thank you. He also tells you that he tried to recruit his friends to join him in this homicidal episode.
Yes, he tested the waters there.
And the words that you put down there was tried to recruit friends. Are those your words or his words?
I think they're his words.
And he had asked them if they shared his philosophical view. Do you recall that?
Yes,
And his philosophical view was, I hate everybody. Right?
yes. Well, that was part of it. It hardly summarizes it, but
Well, these are the words you attribute to him in your notes. Correct?
yes, I'm not sure that summarizes his philosophical view. I wrote down what he said, but I didn't equate those.
Well, when you asked him what philosophical view, you asked the question parenthetically, something about how did you put that? And he says to you, I hate everybody. There's nothing else after that that's part of that philosophical view. Do you agree?
Yeah, all I'm saying is it didn't make much sense to me as a philosophical view.
I appreciate that. One of the other things then is that you have this, I don't know if it's poetry or what, but it's indented and it says, oh, it's my fault. Oh, woe is me. I'll release havoc. Whose words were those?
His.
What was it in response to?
Well, after he said that I hate everybody, he said that they responded that he was depressed. And he, what I wrote down was inwardly directing his suffering. I think that those were basically his words, that's how he interpreted depression, inwardly directing his suffering. And then he says, oh, it's my fault. Oh, woe is me. I'll release havoc.
I'll release havoc. Those are his specific words.
Yes.
On page 9, you ask him about his thoughts, to some extent, about what he appreciates about plans B and C. Do you see that on there? Up at the top, where it says impact on others, your question to him. Do you recall that?
Yes.
And 4 days after the event, unmedicated as he's been for 2 months, he said the bad ones, meaning B and C, wouldn't be good for others. I wouldn't want it to happen to me. Correct?
Yes.
And you asked him, well, how did you deal with that? Do you see that?
Yes.
And he responded with, I turned them into numbers. You see that?
Yes.
Now, one of the things that is completely absent from your notes is any reference to the phrase human. I turned them into numbers. You see that?
Yes.
Now, one of the things that is completely absent from your notes is any reference to the phrase human capital, correct?
Yes, I don't think it came up.
He didn't bring it up, right?
Yes.
He didn't talk to you about transferring value from people that he murdered to himself. That's not anywhere in your notes, correct?
That's right.
When he talks to you, his only reference to numbers is to figure out a way to get past his conclusion that people wouldn't want him to do Plan B or Plan C to them, right?
Well, I wrote down what he said. The bad ones wouldn't be good for others, wouldn't want it to happen to me.
Then you asked him, how would this impact your parents and your sister? Do you recall that?
Yes.
He said, I didn't want to think about that, correct?
Yes.
So fair to say he made a choice to not consider the negative impact on mom, dad, and sister. Fair?
I think it's hard to know what choices he had in his delusional system at that point. This is his answer to the question.
Okay, I agree. Let's ask, no conversation about human capital or value. How about this part here where you talk about him claiming to be catatonic for days? Do you see that?
Yes.
Now, did you ask him when he tells you things like can't move, exhausted, all that stuff, did you ask him, inability to move, did you ask him how it impacted his day-to-day functioning in grad school when that happened?
Again, I recorded this information. What I recall about that is that he tried to have minimal impact on his coursework and what he was doing, so he tried to get that fit into the lunch hour and that sort of thing. So he implied that he was trying to deal with those symptoms with minimal impact.
He tried to fit his catatonia in over lunch?
Yeah, that's what he told me.
Now, in later records review, Doctor...
Well, that's not entirely facetious.
There's no question before you, Doctor. And you'll get a chance on redirect, I'm sure, to clean this up. In your review of the record subsequent to this, one of the things that you noted was that at no time did the defendant, throughout this entire year, ever appear to miss a single class, correct?
I don't recall. I don't know if I know.
Well, you'd have reviewed that as a collateral source to check the accuracy of claims by someone of some mental illness they were suffering, right?
I don't think I did that kind of calculus.
Well, how about the fact that he was going to 24-hour fitness with regularity from January through the early part of July? Did you see that?
I don't recall specifically. I knew he was exercising. I don't know the exact dates.
Did you know that he biked to school and work every day?
I don't recall that.
Did you read or review anything that suggested that he didn't have a single change in observable appearance or hygiene throughout the entire period leading up to this crime?
I didn't come across any reports of that.
How about the fact that he continued to shop for food exactly as he had throughout the course of the preceding year? Fair?
Yes, I was aware of that. He bought a lot of other things.
And we'll get to that. So in terms of how whatever this mental illness was affected his functioning, including his claims to be catatonic, you'd agree with me that the record is pretty clear that it made no observable or substantive change in his day-to-day life. Correct?
He was able to function very highly, yes. He remained organized through this period of time.
Well,
now, he did drop out of school, so
sure.
There was an impact on his life in really probably the most important area to him of his life.
Yeah. And I'm glad you brought that up. He made a decision to drop out of school, didn't he?
He characterized it that way, yes.
Look, here, let me just give you a hypothetical. Guy is introverted. Guy has social anxiety to the max. Okay? But one thing he's got is he's got his studies. He's got his education. The guy rocks it in middle school. Guy rocks it in undergrad. But by the time he gets to grad school, you know what? It's different. Now, instead of just regurgitating things from a syllabus or a book, he's got to interact with people in a lab. He's got to give presentations, and he's got to perform at a different level. And oh, by the way, he's in a program with 5 other people just as smart as he is. And he begins to realize, every dream I had about being a neuroscientist, that's not going to happen. And he drops out of school. Now that could happen without any mental illness at all, couldn't it, doctor?
Could, but it didn't here.
I appreciate your input. My guess is, though, it's happened throughout the country at other times in other majors, correct?
Objection, calls for speculation, lack of foundation.
Go ahead. Doctor, do you know?
Do people drop out of graduate school? Is that what you're asking?
Even after a stellar pre-graduate school academic career.
Yes, but most of them aren't psychotic.
Okay, and I appreciate you adding in all the information you want to get. You'll get that on redirect, okay? When he talked about the catatonia to you too, he also said he didn't think that was a problem either, right? Oh boy, bottom of page 9, doctor.
Yes, he implied he was able to manipulate it to deal with it.
The lunch thing, I got it. Is that what you're referring to?
Yes.
You also asked him about dyeing his hair. Do you recall that?
Yes.
And he doesn't tell you it was to differentiate myself from the other guy. He doesn't say that, does he?
No.
In fact, he tells you, I don't know why I did it. Right?
I remember that. It was somewhat surprising. He really appeared not to have an answer to that question.
At least 4 days after the event, he didn't have an answer, right?
Yes, he appeared perplexed.
One of the other things that you talked about was this mania that, did he use the word mania to describe it?
He did at one point. I don't recall if he did during this interview. Yes, he said he felt the SSRIs, the antidepressants, started the mania. He used the term.
Now, you observed no evidence of mania when you talked with him for those 165 minutes back on July 24th?
Yes, that's correct.
And one of the other things he talked about was a spending spree. Are those his words or your words?
His words.
Now, when he says, I engaged in a spending spree, you followed up and said, wow, that's psychiatrically significant. Tell me about that. Did you?
I didn't say that to him, no.
Did you ask him what he meant by spending spree?
On
the 24th of July, 2012.
I don't recall.
Well, let me ask you.
I didn't record anything more about it.
Is it possible that in advance of this interview, Mr. Bishop told you do not ask about anything related to the planning or execution of these murders?
Yes, I think I've testified to that.
Was this part of that? Did Mr. Bishop say, don't ask him about the spending spree?
No, Mr. Bishop never told me not to ask anything during the interview itself.
So you just heard spending spree, wrote it down, and never followed up?
I didn't write anything else down. I don't. I didn't write anything more down about following that up. He had given me some examples of this.
He did?
So I included, yes.
Like what?
Well, he said it started the mania. He was doing things he never did, spending spree, driving extremely fast. Things were in a super speed. I think he was referring to his subjective mental status, his perception of how things were going. So he gave me those examples. He said he joined an online dating site. He mentioned his hair. So those were all in response to that particular issue and examples. But no, I didn't document any other specific information that might have been related to an episode of mania.
And beyond not documenting it, you didn't ask him any more questions about it, fair?
I don't think I asked him more about that, no.
Now, you brought up the online dating site thing. That's important, too, because one of the things that we're talking about here is the impact that social anxiety has on his willingness to want to engage in interactions with other people, fair?
Exactly, yes.
So in this case, he tells you he joined an online dating site, and you asked him which dating sites.
I don't know anything about dating sites. I don't think I asked him that.
Well, maybe that might be a reason to ask, is you don't know what that means. Did you do that?
Well, I know what it means. I just don't know what the sites are called, so.
Look, this would be important, wouldn't it, is to find out, one, which sites he went to, and two, did they turn into any dates?
In the context of this interview, I did not pursue that.
Now, do you know from subsequent review of the voluminous records here that there were really about 4 different dating sites that the defendant joined? Do you recall that?
That's my understanding.
Do you recall that one of them is called Match.com?
No.
How about HornyMatches.com?
No.
XXXMatch.com?
I don't remember the names of any of them.
AdultFriendFinder.com?
No.
During this meeting on July the 24th, 4 days after this happened, I see no reference in these notes to the defendant talking about a notebook that he generated in anticipation of sending it to someone else. Did that come up in this meeting?
No.
He wasn't forthcoming about the notebook.
No.
Were you told not to ask about the notebook?
I didn't know about the notebook at the time. I don't believe.
Had you known about it, though, you'd have asked about it.
I don't know.
Doctor, look, this notebook, you'd agree, contains the handwritten notes and thoughts of someone who wanted someone else to read them right before the crime. You'd agree with that, right?
Yes, I probably would have asked. I didn't know about it. It's a hypothetical question.
More than just you would have asked, that is a critical piece of information.
There's a lot of critical pieces of information that weren't part of this interview with this preliminary assessment.
I understand. We're going to talk about the one you did later on. I just want to ask if the notebook, had you known about it, would have been part of this one.
It probably would have been.
You are asked by Mr. King about your initial impressions of this guy back on the 24th, and you talked about a serious mental illness and psychosis. Do you recall that?
Yes.
One of the things I want you to do for us is to list for us the delusions you concluded that he had on July the 24th, 2012, based on your interview with him.
And doctor, for the record, what are you referring to?
I'm looking at my notes from the interview.
Okay, thank you.
Judge, can we approach real briefly?
Doctor, did you find it in there?
Did I find the word delusion in here?
Did you find the delusions that you concluded that the defendant had back on July the 24th, 2012, based on your interview with him?
The delusion that at that time I thought he was suffering with was that killing people would relieve both his depression and his suicidal ideation.
That was it. That's what you got off of July 24th?
Yes.
Okay. And that, you actually don't write that down in your notes anywhere, fair?
Well, the notes were process notes during the interview.
Doctor,
No.
you didn't write that down in your notes, did you?
No, it wasn't part of the interview.
Well, and let's go to some other things that weren't part of the interview under your impressions on the last page, 14. One of the things that you did not tell Mr. King in direct examination was that you believe that the defendant has a sociopathic lack of empathy, correct?
Yes.
You also felt like antisocial personality disorder was your secondary part of the differential diagnosis. Is that fair?
No.
Well, maybe I misread it. What's below schizoaffective disorder is primary?
That's basically an abbreviation for autism spectrum disorder.
APD means
I wrote it down wrong, but that's what it meant.
you thought he might have autism spectrum disorder. Is that fair?
That was in the differential diagnosis.
And then
I didn't
below
think-
that, you were-
I've already testified, I didn't think he had that.
I'm sorry. Thank you. And below that, you indicated that secondary SPD, what's SPD? That's schizotypal personality disorder?
I'm not sure. It could be that. I'm referring here to characteristics of his illness.
Well, these are part of your impressions. You'd agree, right?
They're diagnoses that I was considering based on the evidence that I had.
I understand. And the last thing that you thought of, if it wasn't SPD, you put SPD or, what's that word you used?
I put down sociopath.
Sociopath.
Yes.
And
I
these,
wanted to make sure that that got rolled out.
these were your thoughts coming out of that meeting on July the 24th, 2012 with the defendant.
It was not my thought at the time that he was a sociopath. It was my thought at the time that it was important that I be able to rule out sociopathy given the circumstances.
Thank you. Your Honor, now would be a good time if we could to take that break.
All right. Members of the jury, we're going to interrupt the cross-examination of Dr. Woodcock and allow the defense to call their next witness in order to accommodate the next witness's schedule, okay? I'm still looking at getting you out of here at about 5:15. All right. Mr. King, you may call your next witness. Dr. Woodcock, you may step down. 8:30 tomorrow morning. Thank you.
The defense would call Deputy Feenstra.
Deputy, come on up, please.
Sure. And the video.
You come around this way, please. Don't trip. If I could have you raise your right hand for me so that I can administer an oath. You solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. I do. All right, please be seated. Please tell us your full name for the record and spell your first, middle, and last names.
My name is Brent Feenstra. That's B-R-E-N-T. Middle initials W. Last name is F-E-E-N-S-T-R-A.
Mr. King, you may proceed.
Thank you, Your Honor, and thank you very much, Mr. Feenstra, for being so patient with us today. We appreciate it very much. How are you employed, sir?
I'm a deputy sheriff with Arapahoe County.
And how long have you done that?
Ooh, approximately 29 years.
Have you heard of the word retirement?
I have.
Deputy, were you employed for the Sheriff's Department back in November of 2012, sir?
Yes, I was.
And did you at that time, were you present on the 13th of November 2012 at about 5:30 in the morning, assigned to the medical section at the detention center?
Yes,
And in that context, were you involved in moving Mr. Holmes from one of the BC cells to a different cell?
yes, I was.
And was there a video recording made of that transfer, or at least the transfer from the cell that he was taken out of?
Yes,
May I approach, Your Honor?
You may.
I'm handing you, Deputy, what I've marked as Defendant's Exhibit D-TR-68. Can you tell me what that is, sir, if you recognize it?
For the record, counsel showed that to me earlier.
Okay, thank you.
it appears to be the video. It has my initials on the bottom right, and it's labeled Defense TR-68.
Thank you. And have you reviewed that today?
Yes, I did.
And is that a fair representation of the events that took place that we were discussing?
Yes, it is.
I'd move for the admission of the exhibit, please.
Any objection?
I don't object, Your Honor.
All right, it is admitted without objection, and it may be published.
Judge, I can wait to publish it tomorrow just for the sake of the hour and
Okay.
the time.
I don't need to cross-examine on it, so I don't object to that.
All right.
When you entered the medical unit that evening, or morning rather, excuse me, you noticed a strong smell of feces in there, is that right?
Correct.
And you were informed that there was feces in cell BC5, correct?
That is correct.
And you were aware, because you'd been assigned to that unit, that Mr. Holmes was in that BC cell.
Yes,
You and other deputies responded to that cell in order to move Mr. Holmes to a different cell.
correct. We wish to move him across the hallway to a clean cell.
I don't have any further questions about that day, sir. I have one other series of questions for you. At some point on, let's see, in 2014, were you employed at the Sheriff's Department then too?
Yes,
And on the 1st of April, 2014, at about 5:30 a.m. again, were you requested by the command staff or in your superiors there to obtain some photographs of the cell, the MC1 cell that Mr. Holmes was in normally?
that is correct.
And did you, in fact, take some photographs of that
Yes,
cell?
I did.
May I approach, Your Honor?
You may.
I've shown these to counsel. I'm approaching you, sir, with what I've marked as DTR 72, 73, 74, 75, 76, 70, and 71. Okay, I'm sorry. Okay. May I have one moment, Your Honor?
You may. Okay.
I have no further questions.
Okay, all right. Is there any cross-examination, Mr. Orman?
Yes. Good afternoon, Deputy.
Good afternoon.
Good evening. I'll try to keep this as brief as possible.
Do you have a microphone?
I don't know where it went.
The podium.
It's apparently, I do now, Your Honor. Thank you for noticing.
Mr. Brockler was trying to hide it from you.
Yeah. Okay, Deputy, Mr. King was asking you about April 1st and going into the defendant's cell. Do you remember that?
Yes, I do.
And I'm going to show you a group of pictures, and they used to be in order, but now they're not. So I'm just going to go through the numbers individually and I'm going to show them to you and ask you if these are from the defendant's cell on April 1st, okay? So they are pictures 4896, 4902, 4898, 4903, 4904, 4905, 4906, 4907, 4908, 4909, 4910, 4897, 4893, 4899, 4900, 4901, 4911, 4892, 4894, and 4895. And I'm going to show these to you and ask you if this is a complete set of the photographs you took in a defendant's cell on April 1st.
If counsel's going to move to admit, I'd stipulate, Your Honor.
All right, without objection and by stipulation, they are admitted. So that is P-TR-4896, 4902, 4898, 4903, 4904, 4905, 4906, 4907, 4908, 4909, 4910, 4897, 4893, 4899, 4900, 4901, 4911, 4892, 4894, and 4895. 4899 was included in that group, right, Mr. Orman?
I'll have to check.
Right.
And
You mentioned it, and then
Okay.
you started to mention another number, and then you said, "I'm sorry."
Yeah.
And I wasn't sure if the "I'm sorry" was related to the number you were about to mention or to 4899.
it's in there, Your Honor. It was sequential. And just for the record, the way we print these out, they're really slippery, which is sort of why they fell over there. With the court's permission, I'm going to ask to publish a few of these on the document camera.
That's fine?
Thank you. And can I have the handheld microphone to do that, Your Honor?
Yes.
Sir, I'm going to put up first People's Exhibit 4894. Can you explain what we're looking at here?
That's the doorway view looking into the cell. If you're standing at the doorway, there's a window at the back of the cell. Painted areas on the left and right. That's for inmates to hang personal pictures of family, friends, whatnot. The bunk is a wooden bunk, single bunk. The sink is on the very left side towards the front. Really doesn't show. And a mirror is across from the toilet on the right wall. And that's a light fixture above the painted area with night lights and regular lighting in it.
Now, you said you've been in the jail, what, about 30 years?
29.
29. As far as the level of like neatness, is this sloppy? Is it about normal? Is it extra neat for
I
general?
would say it's about average.
Thank you. Now, you talked about these blue painted areas on the walls, and these are for photographs and other things that a person in the jail can put up in their cell. Is that right?
That is correct.
And all the ones in this cell, are they within the boundaries?
Yes,
And if they're not in the boundaries, do you all take corrective action and tell the people, no, you got to keep them within the boundaries?
we usually take them down, leave the pictures on the desk, and give them a verbal warning that keep it. It's mostly for security.
But all these follow the rules, right?
Yes.
Let's take a look at a little closer one on that one on the right, 4909. And that one's pretty full, right?
Correct.
And did you take a closer look at that?
Yes, I did.
And let's take a look at 4907. And the center of that is that a piece of paper with something written on it?
I questioned Mr. Holmes about that.
Well,
'cause I-
hang on, my question is that a piece of paper with something written on it?
Yes, it is.
And like a circle and an infinity sign and the number 1, right?
Correct.
And around that are, fair to say, photographs of young ladies?
Yes,
And by young ladies, I mean, you know, adults.
yes.
And do you know if those are photographs that women have sent the defendant while he's in jail?
From what I know, I believe most of those were sent in within, I'm saying approximately the first 3 weeks from the outside sent in to the jail.
Okay, okay, thank you. And let's look at one more too. And this is 4902. And that would be a closer photograph of that.
Correct.
And this was taken in the defendant's cell on April 1st of 2014.
That is correct.
Thank you. Can I have a moment, Your Honor?
You can?
I don't have any further questions.
All right. Is there any redirect?
No, sir.
All right. I don't believe those questions are for this witness. So may this witness be released from his subpoena, Mr. King?
Yes, Your Honor.
Is there any objection, Mr. Orman?
None, Your Honor. Thank you.
Okay. All right, sir, thank you.
Thank you.
All right, members of the jury, it's a couple of minutes later than I hoped, and I appreciate your patience. Please remember that the admonishments I have been giving you throughout are extremely important. Please make sure you're careful to follow each and every one of them. Get some rest tonight. I'll see you tomorrow morning at the usual time. Thank you. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. I believe that Mr. Edson had asked to address the court about an upcoming witness just briefly. Is that right, Mr. Edson?
Yes, Judge. I'll be as brief as I can. Your Honor, I've been informed by the defense that they plan to call tomorrow Larry Daniel, D-A-N-I-E-L. He is from Guardian Digital Forensics and was endorsed by the defense on December 16th, 2014 within D-261. Within that endorsement, the defense indicated that Mr. Daniels, is an expert in the field of forensic examination of computers and electronics, an expert in the field of cell tower technology and analysis, and that his curriculum vitae had been provided to the prosecution on the date of the filing, which would have been December 16, 2014, and that Mr. Daniels' disclosure statement had been provided to the prosecution on the same date. A further supplemental disclosure on listed 278, this would have been January 30th, 2015, indicated that Larry Daniel will eventually receive and may review all email evidence. What's pertinent here, Judge, and what the main issue from the prosecution perspective is we have received no reports, no written summaries at all from Larry Daniel. What we do have is a one-page memorandum, which I actually would like to tender a copy to the court from December 16, 2014, which lists, Larry Daniel lists the items of evidence he reviewed from the Aurora Police Department, indicates that he and his consultants forensically processed the digital forensic images of the items above, and this relates to the computers and tablet items that were recovered from Mr. Holmes, from the defendant's apartment, and extracted the raw data from each item, and then talks about his training and experience and indicated that Larry Daniel did not generate a written report, and goes on to talk about how Larry Daniel reviewed Special Agent Scott Eicher's material related to cell tower analysis. If I may approach, Judge, I would like to tender this to the court for the court's review.
Why don't you mark it as a court trial exhibit or as a people's exhibit, either way?
I will do so, Your Honor.
Actually, maybe better a court trial exhibit to avoid confusion.
Would the court like this now or after my argument?
You can provide it after your argument.
Thank you, Judge.
But for the record, what is the next number?
76.
All right, so mark it as C-TR-76.
Understood. So, Judge, I've been in off-the-record conversations with the defense, trying to ascertain exactly what Mr. Daniel will be testifying to. As of this date, we still have no report. We still have no written summary. We have no information written that as to what Mr. Daniel is going to be testifying to. I was provided this morning with a copy of some photographs and evidence, and a lot of it actually is from the Aurora Police Department. There is a couple of items that are not from the Aurora Police Department that I've been told Mr. Daniel will be testifying to. We requested from the defense an opportunity to meet with Mr. Daniel personally so we can find out what exactly he's testifying to, and I received word this morning that Mr. Daniel respectfully declines a meeting with our office. Judge, we believe this falls directly in line with the court's ruling in P43. In P43, the people filed a motion for expert witness discovery pursuant to Rule 16 2B, Roman numeral 2B, and the court issued its order in the order regarding people's motion for expert witness discovery pursuant to Rule 16, Roman numeral 2B, P43. The court talks not only in P43 but also in some other orders, including D251, which the court's order is related to the defendant's motion to compel supplemental expert disclosures. Court cites numerous cases, including People v. Castro at 854 P. 2nd, 1262. It's a Colorado Supreme Court case from 1993. That the discovery rules in the criminal proceedings are designed to further the truth-seeking process. The court in D251 and P43 cites Lenari v. People 827, Pacific 2nd, 495, Colorado Supreme Court case from 1992. By allowing the prosecution and the defense to acquire relevant information before the trial, the rules promote fairness in the criminal process and reduce the risk of trial by ambush. And People v. Robles, 568, P. 2nd, 57, Colorado Supreme Court case from 1977, indicates that trial by ambush is no longer acceptable means for ascertaining the truth. Judge, we have no idea in any sort of written form and no meaningful way to cross-examine this expert of the defense. And specifically, again, referring to the court's ruling in P43, the court cites Criminal Rule 16, Roman numeral 2, subsections B1 and B2, in which those rules specifically state the court may order the defense to disclose the underlying facts or data supported in any opinion. We have none of that, Your Honor, of an expert endorsed witness. If a report has not been prepared by that expert to aid in compliance with other discovery obligation, the court may order the party calling the expert to provide a written summary of the testimony. We don't have any of that, including the results of any physical, mental examinations, scientific tests, experiments or comparisons, particularly related to the comparisons, we have no information related to that. The intent of this rule specifically talks about the fact that it allows the prosecution sufficient meaningful information to conduct effective cross-examination. So as we sit here tonight, Your Honor, with this potential expert witness being called by the defense tomorrow, we have a copy of an exhibit that the defense intends to introduce through him. We have verbal assertion that he will be qualified as an expert, yet we have no reports or summaries whatsoever as to what exactly he's going to be opining on or any of the underlying data in which he's relying. Thank you, Judge.
And what relief are you requesting?
But this time, Judge, we are requesting that, first of all, we don't exactly know what he's going to testify to, but the relief that we're looking at is that he not be allowed to opine in any sort of way in expert capacity in any area that is specifically listed in this memorandum, which quite frankly is not really outlined. It's talking about how, in relation to this case, he forensically processed the digital forensic images and extracted the raw data from each item. It's not even listing exactly what he's going to be testifying to. So the relief that we're asking right now, Judge, is that if he's going to be testifying as a lay witness, that's one thing, but it's been asserted that he's being testifying as an expert witness. And quite frankly, the information in this memorandum that he's going to be testifying about, all of it is expert information. So if he's testifying as a lay witness, that's one thing. But if he's testifying as an expert witness, we have none of the underlying information. We would request that the court not allow that type of testimony in this particular case. Thank you, Judge.
All right.
If I may approach, I'll give the court CTR 76, please.
Yes, please. All right, who wants to respond? Ms. Spengler? Thank you.
Your Honor, we endorsed Mr. Larry Daniel as an expert in the field of computer forensics and cell tower analysis back in December of 2014. And we did include and provide to the district attorney the disclosure statement that I believe complies with the court's order in P54. The reality is Mr. Daniel didn't generate a report. He reviewed data that was extracted from the electronic devices by APD. He's going to be called tomorrow, and he's not going to be testifying to anything outside of what the prosecution has, what APD extracted. The prosecution has introduced certain electronic evidence, certain computer evidence, certain screenshots. They can highlight certain parts of the computer evidence that they've chosen to. And the reason for and the purpose for calling Larry Daniel is to do the same thing, to highlight other parts of the evidence. I think the problem, or the issue here, is that the amount of material is just so voluminous. There's a ton of data that came out of these computers in the iPhone. But Mr. Edson is not in a significantly different position than I was on the heels or the night or the eve of cross-examining Detective Gordon Madonna. The reality is the testimony is reactive to what came up during the trial. For instance, Mr. Edson, through Detective Madonna, introduced a series of websites that were bookmarked, but not all of them. I would introduce, and the district attorney has, and APD has, all of the websites that were bookmarked on a particular computer. So again, there's just nothing outside of what the district attorney has for the extraction by APD that Mr. Daniel's going to be testifying about. It's just a lot of data that APD extracted.
What about the cell tower?
I'm not going to ask questions about cell tower analysis. I'm not going to go into that.
Okay, so he essentially processed some of the digital images in this case, or he processed the computer and some other electronic devices. Is that what it was?
That's right. So APD and Detective Madonna testified about how they extract the data from the original devices, original computers, and the iPhone. And Mr. Daniel received a copy of that. And Mr. Daniels also received the APD report. He's also received the sort of data that APD provided as well, and has reviewed that.
And he's going to talk about how he went about extracting data from the computer and other electronic devices.
I frankly don't intend to go into the details unless we have to. It would be more just a matter of producing For instance, publishing screenshots that have already been admitted by the prosecution that weren't published, that were on one of the computers, talking about certain evidence from the iPhone. And I've provided this, that the district attorney has at APD extracted. I mean, I've talked to the district attorney, and I've given the district attorney a copy of the exhibits. It doesn't contain my entire cross-examination, but I mean, I've advised them as to, sort of the areas that I intend to go into, and it's reactive to what's been presented by the district attorney.
So it's going to be items that have already been introduced by the prosecution, plus the exhibits, the photographs that you showed to Mr. Edson?
I mean, I believe that's correct. I don't know if there's, a part of the iPhone analysis that I might go into that I don't have an exhibit for. I might ask a question about a search term on one of the on the Lenovo computer, and I don't have an exhibit for that. But again, that's all information that they have that APD extracted. It's nothing new. It's nothing additional.
But when you say you might ask a question about a search term, the question would be along the lines of whether there was a search term that was found in the iPhone that was recovered, or something along those lines.
Or a computer.
Or a computer, as opposed to having him offer opinions about what it means or what it doesn't mean for purposes of the investigation or for purposes of the charges.
Well, I listened to the court when the court was talking with Detective Madonna, and I agree. I don't think it's fair for him to elicit opinions about mental state or anything like that. I think he can offer opinions as to whether the data is there or not there, and whether it was accessed or not accessed, that type of stuff.
Okay. All right. Mr. Edson? It sounds like she's planning on having the same type of presentation that you did with Detective Madonna, and that she's not going to ask any opinions about the meaning of certain specific content, but rather talk about search terms that may have been found and other contents of that were found in the computer, that were extracted from the computer, that were extracted from electronic devices, and things to that effect.
Well, our position, Judge, is if this witness is going to be opining as an expert in any capacity, that he is limited to exactly what is contained within this memorandum that I just pertained to the court. And I quite frankly still believe that if he's even going to be opining in those areas that the court just described, that he's relying on the extracted data. That's an expert type of analysis. And he talks about the fact that he extracted the raw data from this information, and that he relies upon his training and almost 15 years of experience in this field. So it's going to be an expert opinion in that sort of fashion. And again, we have no underlying data or reports or anything related to comparisons for his expert opinion in those areas. So, Judge, it's going to be outside the scope of what we've been provided here. At the very least, Judge, we are requesting that the court order that the defense not be allowed to call Mr. Daniel to testify until he at least agrees to meet with us, because we have no idea exactly, and this is an offer of proof by the defense, but we haven't heard or seen anything from Mr. Daniel exactly what he's going to be testifying to.
Well, I can't force a witness to speak with you. You know that. So the question is, other than having him or having more information about how he went about extracting the information from the computer and other electronic devices, what else is it that you believe that you're entitled to? I'm assuming that that's what his expertise goes to. I think the expertise would go to the extraction of the information from the computer and electronic devices. Beyond that, he can talk about the results of the extraction, what search terms were found, what queries may have been found, what contents were found, sort of like you did with your witness. But it sounds like the expertise would go to what software, for example, he used, or what methods he used to extract the information from the computer and other electronic devices.
Exactly right, Judge, and we don't have any of that information. And that was the difference is from our experts, that was provided in August of 2012 with all that information. All of the software the court heard a Shrek hearing on this, all of the software that was used, all the processes that was used to extract all of this type of data. None of that we have, Judge.
All right. Ms. Spengler, to the extent you're going to have him testify as an expert about extracting information from the computer and other electronic devices, at this time, your disclosure falls short of my order P43 and my order D251. So you have to provide some kind of summary. I understand that this expert has not done a report, but you should provide a summary to the prosecution related to how he went about doing this in general, what software he used, what methods he used, and in general, his opinions about that aspect of his examination.
And Your Honor, if he testifies then just to the information that APD extracted, then...
So not as an expert, but just as someone who has general knowledge in computers and electronic devices?
I mean, I'm sorry.
No, that's okay. And just talking about just sort of the same results or different results from the extraction that the Aurora Police Department did?
Not even different, just additional, because again, there's so much material, and the prosecution presented a very small amount, and we would just be, highlighting some of the other evidence that was not presented.
Mr. Edson said that if he testifies as a lay witness, that's one thing, and it doesn't sound like he has an objection to that. I think his objection was to not knowing more if he was going to testify as an expert. So if you're just going to highlight some of the information that has already been admitted as having been extracted by the Aurora Police Department, then that may be a different story. I don't know. Mr. Edson?
I don't know how he can testify as a lay witness when he is looking at the raw data and the extraction processes that APD used to find these search terms and these images and such. I mean, he's relying upon his expertise to do that. So I don't know how he can be qualified as, or not qualified, but how he can be put on the stand as a lay witness. He's going to be relying on his expertise.
It's hard for me to know, Ms. Spengler, because I don't know exactly what he's going to say. Here's what I'll tell you. If you don't provide a report, you run the risk that I'll sustain objections to beyond the scope of what was disclosed. So you figure out how you want to proceed. You can run the risk, or you can do a report and go from there. I don't know whether his testimony is really going to be truly lay witness testimony, or if I'm going to find that it's expert witness testimony. I don't know, because I don't know exactly what he's going to say. I'm being told in vague and general terms what he will testify about, but I don't know what questions you're going to ask, and I don't know what testimony you're going to elicit. So,
okay, I understand the court's ruling, and I just want it to be clear that this was disclosed, this report was disclosed, or disclosure statement was disclosed back in December of 2014. The first time that anyone in the district attorney's office reached out to talk to Mr. Daniel was yesterday. So I don't, or the day before, so I don't understand,
well, you're saying that if they had reached out earlier, he would have agreed to talk to them?
I mean, it's a matter of timing. I mean, it's just, it was so rushed. But I mean, I'm not going to speak for him in that circumstance, but if this is so important to the district attorney, I just don't understand why it wasn't brought up earlier.
I understand, and I agree with you that this is something that they should have inquired into earlier or about earlier, but the bottom line is my orders, P43 and D251, apply regardless of whether they are attempting to reach out to speak to a witness. My orders are not conditioned on whether an expert witness agrees to talk to the opposing party. My orders say that if you're going to call an expert, then you have to provide a particular type of disclosure. And this disclosure, C-TR-76, does not satisfy the requirements in my orders. So if you're going to call him as an expert, you should provide a summary of, in general, the opinions he's going to offer and the basis for those opinions. And if you want to take your chances that this is not expert testimony and call him as a lay witness and think you can lay enough foundation and still have it be admissible, that's up to you, but you run the risk that I may disagree with you and I may say, no, this is expert testimony, and then at a minimum, it'll cause a delay in when you call him, and you'll have to call him later, or perhaps not call him at all. So that's about all I can tell you, all right? Okay, is there anything else at this time on behalf of the people?
Thank you.
Anything else on behalf of the defense? Yes. Yep, no problem. All right, thank you. Here you go.